morning, everyone. Thanks for attending this morning. My name is Jamie Talt. I am a special counsel in the employment group here at FMLA. My practice focuses largely on defending employers in litigation and administrative charges and providing advice and counsel on various employment topics.
Good morning, everyone. My name is Margaret Salisbury. I'm an associate also with the employment group here at Frella and have a similar practice group as Jamie. So we're really excited to have you with us today. So as a brief overview for what we'll be talking about, we're going to be going over about 15 different leaves that are important for California employers to know about. While today we're not going to be going over FMLA or CFRA or paid family leave, you're welcome to contact me or Jamie with any specific questions you may have that come up based off the topics. And in addition to going over the leaves, we'll also be highlighting which ones will be paid, which ones are protected and unpaid, and sometimes where employees may apply their compensatory time off to cover the otherwise unpaid leaves. So please feel free to shoot questions in the chat as we're going, and we're happy to answer them at that. So for our first leave, we'll be discussing voting leave. So all employees in California can vote during their work hours. And this is one of the few leaves that we are talking about today that are paid. But the employers are just limited to just 2 hours of paid leave, even if the employee needs to take more time than that. So important responsibilities for the employee. They should give notice at least 2 working days to their employer if they think they'll be voting during the workday. And the statute also requires that the employee does as much as possible to minimize that disruption to their work schedule, including maybe taking that time off in the beginning or the end of their shift. Employers have also a strong notice requirement. So you should be tracking all statewide elections. That includes state elections, federal elections, and then just make sure you're tracking any of California's proposition voting that may happen in off years. You have to post a notice about 10 days before any of those elections, informing your employees of these voting rights. And you can find that sample language on the Secretary of State's website, or also call this number to order posters. And we'll be linking that sample notice in our follow-up email today.
So I'm going to talk about military leave next. I think, as the situation in the Middle East progresses, National Guard and reservists are called to serve. Employers may have employees who require leave to fulfill their obligations to the military, and that is protected. So, under federal law called USERRA, which is the Uniform Services Employment and Reemployment Rights Act, employees are entitled to take protected leave from employment to engage in military service. And then California law also provides additional leave protections for eligible military service members and their covered family members under various laws. So one such law is CFRA, which you might already be familiar with, but there's also protections under the California Military and Veterans Code and the California Civil Air Patrol Employment Protection Leave Act. So focusing on California's Military and Veterans Code, it provides additional unpaid leave, not just for military service, but also for training. So, for members of the Reserve Corps of the U.S. Armed Forces, National Guard, or the Naval Militia, they get 17 days per calendar year to engage in military training, drills, encampment, naval cruises, special exercise, or similar activities. And that includes travel time. For members of the California State Guard, they get 15 days per calendar year to engage in similar activity, again, including travel time. So The Military and Veterans Code is silent about whether employers can require or allow employees to substitute accrued paid leave during what's otherwise this unpaid leave. USERA, however, so the federal equivalent, requires employees to or employers to permit employees to use accrued vacation or other paid time off during their military leave. USERA also requires employees on military leave the option to continue their health insurance coverage by self-paying the coverage cost. And for employers that might have employees in San Francisco here, San Francisco also has its own Military Leave Pay Protection Act. This applies to private employers with 100 or more employees in any location. And then covered employees include part-time and temporary employees who are members of the Reserve Corps of the U.S. Armed Forces, National Guard, or other U.S. uniformed service organization, and who work in San Francisco. So the ordinance requires that covered employers pay supplemental compensation to those eligible employees when the employee's on leave for military duty up to 30 calendar days in a calendar year. The supplemental compensation is essentially the difference between the employee's gross military pay and then the amount of gross pay that the employee would have received based off of the employee's regular work schedule. Okay, next slide. Okay, switching now to reinstatement obligations. So USERA and California's Military and Veterans Code also provide for reinstatement for those employees returning from military leave or military service. So focusing here on California law, it provides protections for certain employees in the National Guard who leave their job but want to be reinstated following their release from service. And in that case, the employer has to consider that person as having been on a leave of absence during that period. So these protections apply to former employees who were an officer or enlisted member of the National Guard of any state, were called to active duty by the governor of the state where they serve or by the president. They must have received a certificate of satisfactory service in the National Guard or an equivalent certificate. They must be still qualified to perform the duties of that former position they want to return to. And they have to timely apply to have their employer treat their absence as a leave. And if the former position was full-time, and was not a temporary position, then in that case, the former employer must, one, reinstate the employee to either their former position or a similar position with similar seniority, status, benefits, unless the employer's circumstances have so changed as to make it impossible or unreasonable to do so. And another requirement for employers is in these situations, they must not discharge the former employee from the position without cause within 1 year of reinstating them to their position. And there's also similar protections for part-time employees as well. So to be eligible, employees have to timely apply, as I said. For full-time employees, that's within 40 days from release of service. It's a much faster timeline for part-time employees. They have to apply for this within 5 days of release of service. Okay, next slide. Switching to military spouse or domestic partner leave. So this protection was passed in 2007 by Governor Schwarzenegger. The purpose was to provide families of troops serving in military conflicts in Iraq and Afghanistan time together during the service members' leave from deployment in a combat zone. So these protections apply to all employers with 25 or more employees. Um, and spouses and registered domestic partners of military members on active duty are entitled to up to 10 days of unpaid leave while the military member is on leave from deployment during a period of military conflict. This law is separate from and does not change the obligations of employers covered by FMLA or CFRA to provide qualifying exigency leave or leave to care for an ill or injured service member. So this is completely separate. Um, and employees are eligible if they meet two requirements. First, they have to be the spouse or registered domestic partner of a member of the National Guard or reserves deployed during a period of military conflict, or be a spouse or registered domestic partner of a member of the U.S. Armed Forces during a period of military conflict to an area designated as a combat theater or combat zone by the president. Um, the second requirement for employees to be eligible is that they work more than 20 hours per week on average. And a period of military conflict here is defined as either a period of war declared by Congress or deployment for which a member of the reserve component of the armed forces or National Guard is ordered to active duty. So next slide. A little bit more about this spouse and domestic partner leave. As noted on the slide, there are notice and certification requirements the employee must meet to be eligible for the protected leave. So for notice, employees must notify their employer of the intent to take leave within 2 business days of receiving official notice that their spouse or domestic partner will be on leave. Um, and then in terms of certification, employees must provide written documentation certifying that their partner will be on leave from deployment during that leave period. And while this leave is unpaid, employees can use accrued vacation time, paid time off, or sick time to receive pay during this leave. Um, and again, as I mentioned in the beginning of these military slides, just given the current geopolitical climate we're in, I think it's important to keep these protections in mind, both when dealing with employees who serve themselves or have family members who serve.
So next up is jury duty leave. I'm sure we all know from personal experience getting the summons in the mail. Employees are eligible for protected unpaid time off without any adverse actions if they're completing jury service. So employees must give reasonable notice of jury service. While there's no specific time frame defined, one best practice could be to encourage employees to inform their employers as soon as they have received that jury summons. And you may not know how long you're going to be serving on a jury, especially if you are selected. But you can also encourage the employee to stay in contact throughout that process, especially if they do get selected for a trial and get to hear an anticipated trial length. And some other important things to remember is you can ask the employee for proof of the jury service, which they should have. And you cannot coerce employees into not attending. And this is another category where, while it's unpaid, and employees may use their accrued time off to receive pay during that time. So similar to jury duty, employers must also allow employees to take protected unpaid time off to comply with a witness subpoena. And again, you can ask the employee for a copy of that subpoena, or if it came via notice from the court. And similar to jury duty, employees must give reasonable notice after receiving a subpoena or court notice. And you can just encourage through policies to request that the employees inform their employer as soon as they have received that documentation. As we'll talk about more later, this can include employees who have been a victim of a crime or who are serving as a witness. And similar to some of the other categories, while this is unpaid, and employees may choose to use their accrued time off.
Next, we're going to switch to school activity leave. So, employers with 25 or more employees at the same location must allow eligible employees of school-age children to take up to 40 hours off per year to either find, enroll, or re-enroll their child in a school or with a licensed childcare provider, or participate in activities of the school or that licensed provider, or to address a child care provider or school emergency. The law limits time taken under the first two bullet points, so the finding or enrolling protections and then the activities protections, to 8 hours per calendar month. But there is no limit on time taken to address a child care provider or school emergency. And this applies to employees who are the parent, guardian, or custodial grandparent of a child in kindergarten through 12th grade or a licensed daycare. In terms of notice, employees must give their employers reasonable notice of their intent to take leave under these laws. And employers can choose to require employees to present documentation from the school or the daycare facility to prove that the employee participated in those activities. And again, while the time off is unpaid, the employer can allow or require the employee to use any accrued vacation or PTO time that is available. Now, if two parents work for the same employer, the first parent to give the employer notice is entitled to leave under the labor code. The second parent, if who still wants to participate, must separately request the leave with the employer, have that be approved, but it's not protected like it is as the first parent's request under the labor code. And then also separately under the labor code, and this applies to all California employers now, not just those with 25 or more employees. Employers are prohibited from discharging or discriminating against an employee who is a parent or guardian of a student, and the employee takes time off with reasonable notice to appear at school because the student was suspended and the school district they're in has a policy that the parent or guardian has to attend part of the school day of in the classroom of that student. So there's additional protections applicable to all employees in that sort of suspension situation. Okay, next slide. So we'll talk about emergency personnel leave now. California law provides protected leave for employees who are volunteer firefighters, reserve police officers, and emergency rescue personnel. And then in addition, employers with 50 or more employees have to allow those employees to take unpaid leave for related training. The time off permitted for training is 14 days per calendar year. It does not have to be taken all at once, and there's no time limit for emergency duty leave. There's also no notice or certification requirements for this leave. And while the leave is unpaid, employees can choose to use, again, accrued vacation time, paid time off, sick time to receive pay during their absence. And I think with how prevalent wildfires are and continue to be growing in California, you may see more employees who either are in these roles or sign up for these roles in their communities, in particular volunteer firefighters, and become eligible for these protections. Okay, next slide. So next is emergency conditions leave. So California's Workers' Rights in Emergencies Act provides protections for employees in emergency situations, such as natural disasters that may make the workplace unsafe. The Act prohibits employers from taking or threatening adverse action against employees for either leaving or refusing to work when the employee has a reasonable belief that the workplace is unsafe due to an emergency condition. This leave applies to all California employers. An emergency condition means the existence of either conditions of disaster or extreme peril to the safety of persons or property at the workplace or work site that's caused by natural forces or a criminal act. Or emergency conditions means an order to evacuate a workplace, a work site, a worker's home, or the school of a worker's child due to a natural disaster or a criminal act. Emergency condition, though, does not include a health pandemic. So, these protections won't apply, for example, if an employee says they feel unsafe due to COVID-19. And a worker's belief is reasonable if a reasonable person would conclude there's a real danger of death or serious injury if that person enters or remains on the premises. In terms of leave time, there's no fixed amount. It varies depending on the emergency condition and that employee's reasonable belief as to the unsafe workplace or work site. But basically, once the emergency condition ends, the protections end. Notice, employees must notify their employer of the emergency condition requiring them to leave or refuse to report to the workplace or work site, either, if it's feasible before leaving or refusing to report, or when that notice is not feasible, just as soon as possible. In the event of an emergency condition, employers cannot prevent any employee from accessing their mobile device or other communication device for either seeking emergency assistance, assessing the safety of a situation, or communicating with a person to verify their safety. So, for employers that have policies restricting cell phone usage at work, for example, I think it's important that employees enforcing those policies should be mindful of this exception in situations that can be perceived as an emergency condition. And this is another type of leave where it's unpaid, but employers can use their accrued vacation, or employees can use their accrued vacation time, paid time off, or sick time. Violations of these protections can result in PAGA claims, although the statute does provide a cure provision to correct any alleged violations. And I think circling back again to wildfires, that's an example of a natural disaster that has caused extreme peril to employee safety, at their homes or workplace or children's schools. And that would qualify as an emergency condition, for example, if there was an evacuation order from their home or the employee reasonably believes that the work site's unsafe.
Okay, so for the next few slides, I'll be going over a couple different types of leaves for employees who have been victims of a crime or who have family members who have been victims of a crime. First, we'll go over some government code provisions, but there'll also be some overlaps with a few sections of the labor code. These are pretty complicated and have involved recent legislation from the past several years that have changed the requirements a little bit. So we would encourage everyone to look at a fact sheet from the California Department of Civil Rights, which we will link to in our follow-up email. So the beginning of the statute from the government code just describes two pretty broad types of leave. The first is for victims of any crime who just need time to obtain relief, such as a restraining order. And unlike other things we'll talk about in a second, this can just be any crime or any public events. Additionally, as of the beginning of this year, employees who are victims or who have family members who have been a victim may also take protective leave to attend judicial proceedings related to that crime. And this is not limited to just witnesses who have a subpoena or a court order to appear. And this type of leave is a little bit more limited to certain serious and violent felonies, such as stalking and sexual assault. For these two different types of leaves, employees may use their vacation, PTO, or paid sick time. And if for some reason the absence would also qualify under FMLA or CFRA, the leave must run concurrently. So it's going to be counting towards those total days employees are allowed. So next is for leaves applicable to employers that have 25 or more employees and have a bit more specific types of crimes these apply to. So this allows leaves for, and in the next slide, we'll go over accommodations for similar acts of violence. And this is for employees or family members who have been victims of a qualifying act of violence. So this is not an exhaustive list of what's in the statute, but overall it's domestic violence, sexual assault, stalking, other acts of violence and threat of force, and especially any act involving a firearm. And one of the recent legislation changes was expanding the definition of what a family member means to include child, parent, grandparents, grandchildren, spouses or domestic partner, or a designated person, which is a term you may be familiar from CFRA, which can mean someone that has a family relationship to the employee but may not be blood related. So for most of these leaves for employees, the leaves will be limited to a total of 12 weeks unpaid time. But in certain situations, if they're taking leave to take care of a family member who's been a victim, that's going to be limited to 10 days. And if you're taking leave specifically to relocate housing or to re-enroll your child in a new school or childcare, that is limited to 5 days of leave. So again, this is more exhaustive in the statute, but just to get a sense of what leaves are allowed, similar to what we discussed before, to seek some sort of relief like restraining orders, or to get some sort of legal services, whether that's civil or criminal. Also taking leave to seek medical attention or mental health services, to obtain victim services like domestic violence shelter, going to a rape crisis center, or other victim services organizations that may exist for that specific crime. And the limited to 10 days would be providing care to a family member who is recovering from injuries from these certain crimes, or to seek or provide childcare. So for the same employers of 25 or more, for the previously discussed acts of qualifying violence, some employees may also be entitled to workplace accommodations when they do return from work. And this is especially for crimes that may be ongoing or have a threat of being ongoing, like domestic violence and stalking. And some reasonable accommodations they may ask for may be a worksite transfer, some sort of modified schedule, changing their work number, or asking for more safety features at work, such as reissuing keys, changing locks, adding a lock to their specific office. And as with all accommodations, employers must engage in the interactive process to both determine what's reasonable for that specific employee for their specific circumstances, and also what may constitute an undue hardship for the employer. And employers may request written certification to prove that that employee or their family member was a victim and there is some sort of need for accommodations. So these are notice requirements for all of the different crime leaves and any size employer that we just discussed. And so for these sections, employees may take their vacation time, personal leave, or sick time. But if it does qualify under FMLA or CFRA, these leaves would run concurrently. And employees, as much as possible, should try to give advance notice of their time off. But of course, this may not be feasible in some crime situations. And if that happens, and the employee needs to take an unscheduled absence, employers cannot take disciplinary action if that employee is able to provide some sort of certification within a reasonable time upon their return. And of course, reasonable is going to be, fact specific for that situation. The statute allows a pretty broad category of what certification means. This may be something more official, like a police report, a court order, a subpoena, or some sort of documentation from medical professionals or victim advocates. So this can include domestic violence counselors, sexual assault counselors, and other specific counselors which support these victims. And it can also be, to the other end of the spectrum, just a written statement that is signed by the employee certifying that they have been a victim or their family member has been a victim. So some of the obligations that employers have, both for the 25 and up or just for any size employer. So you're required to inform the employees of their rights under this government statute at several different points. So at the time of hiring, annually, upon an employee's request, and as soon as an employee informs the employer that they or the family member have been a victim. And like we mentioned before, the Department of Civil Rights has a great model form in addition to their fact sheet. So you can use this language to create your notice or use it to inform your own notice that you may want to create. And for any sort of these leaves or accommodations, it's important that you keep these records confidential and not share for the reason why the employee may be absent. Of course, the employee is welcome to share that information with people as they wish, but the employer needs to keep that information confidential. So expanding a little bit more on other types of victim leaves, there are 2 labor code sections that are now part of the Fair Employment and Housing Act. And this is to further protect crime victims from employment discrimination. And so you can see there's some overlaps with the government statute we just covered. So the first labor code statute is really broad. It's just to cover employees or their immediate family members or spouses to attend any type of judicial proceedings and to protect them from discrimination that may occur from that absence. And for this section, the statute allows the employee to take any sort of compensatory time off that they have accrued. The second labor code focuses on the employees or certain family members who are victims of certain felony crimes, like vehicle manslaughter, felony child abuse, who need to obtain some sort of relief, like a restraining order. And for some reason, they're allowed to take their vacation, personal leave, and other time off, but specifically not allowed to take sick leave. And both of these labor code statutes do not require leave to run concurrently with FMLA or CFRA. Similar to the notice requirements under the government code provisions we just discussed, employees should try to give their employer reasonable advance notice of a scheduled proceeding or an absence to obtain a restraining order. Of course, this may not always be possible, so they can provide a copy of the documentation that's relevant to their absence within a reasonable time when they return. And employers should allow the leave of any length. There's not that limitations that we saw in the government statute, but there's also an expectation and a requirement to keep these records confidential.
So I'm going to switch now to alcohol and drug rehabilitation leave. These protections apply to employers with 25 or more employees, in which case all employees are eligible for leave to voluntarily complete a rehab program. There's no time limit for how much leave is protected under these provisions. It just has to be a reasonable amount that does not cause undue hardship. So lengths of rehab programs can vary greatly. There are short-term programs that are just a couple weeks, up to even 90 days. So whether the length causes an undue hardship, it's a fact-intensive analysis and it can be hard to prove. Minor expenses or inconveniences to the employer are insufficient. But beyond that, it depends on the specific individualized assessment of the employee's job, the leave, and the employer's resources. So if this comes up, this might be a situation where you want to loop in outside counsel and get some advice. Employers must keep confidential information about any employee entering a rehab program. The statute here specifically states that the employer must not disclose that the employee has enrolled in an alcohol or drug rehabilitation program. Employees may choose to use available sick leave concurrently with the rehabilitation leave. But notably, unlike other statutes we've covered today, some of which permit employees to apply, various paid time options like sick leave or PTO or vacation. Here, the law only provides for use of paid sick leave to receive payment for otherwise what is this unpaid leave protections. And if an employee is also eligible for FMLA or CFRA, an employer may treat drug or alcohol rehab leave as FMLA or CFRA leave. The statute does not provide for a private right of action if there's a violation, but eligible employees can file a complaint with the labor commissioner if they feel they've been denied a reasonable accommodation pursuant to the statute. And so let's talk about what happens though if an employee only seeks to enter a treatment program after they've been caught in violation of a drug use policy. While there isn't case law analyzing this labor code provision does specifically say that the statute does not prohibit an employer from refusing to hire or discharging an employee who, because of their current use of alcohol or drugs, is unable to perform their duties or cannot perform the duties in a manner which would not endanger their health or safety or the health or safety of others. And then somewhat relatedly, while employers generally have to make reasonable accommodations, no state currently requires accommodation of federally illegal drugs, even medical cannabis, for use on the job. So, in California law explicitly states that on-the-job use is not a reasonable accommodation. So, in terms of these labor code protections here for alcohol and drug rehab leave, these protections are really meant to cover times when an employee has not violated a workplace drug policy, but is otherwise, voluntarily seeking to complete a rehab program.
So next we have leave for employees who may be donating organs or donating bone marrow. And so this would be applicable for employers with 15 or more employees. And employees are eligible for paid leave. For organ donations, this is up to 30 business days. And for bone marrow donations, this is up to 5 business days. And this would be per year. Unlike some of the other categories, employers can actually require the employee to apply some of their sick or vacation time to count towards this paid time off. For organ donors, this would be up to 2 weeks if they have it accrued. And for bone marrow donors, this would be up to 5 days. This type of leave can also be intermittent. It does not need to be taken all at once and can be taken one or more periods throughout the year. For this type of leave, employees must provide pretty clear written certification from a medical provider confirming that they are a donor and that there is a medical necessity for their period of leave that they're requesting. And some more specific requirements for employers here. These leaves are separate from and do not run concurrently with FMLA or CFRA. And you can also not treat their absence for a donation leave as a break in their continuous service. You also need to maintain that employee's group healthcare coverage during the leave and be able to restore the employee to their original position or an equivalent one.
Switching now to bereavement leave. So, for employers with five or more employees, they must provide bereavement leave when an employee has a death of a family member. And family member is specifically defined as a spouse or a child, parent, sibling, grandparent, grandchild, registered domestic partner, or parent in law. All employees are eligible so long as they've been employed for at least 30 days before the leave start date. So, not the request date for the bereavement leave, but when the leave is actually intended to start. Eligible employees are entitled to 5 days of bereavement leave. And those 5 days don't have to be taken consecutively, but they do need to be taken within 3 months of the family member's death. And again, although bereavement leave is unpaid, employees can use their accrued paid sick days, vacation, or personal days to receive pay during their bereavement leave. The statute also allows employers to request documentation of the family member's death. Example of that kind of documentation can include death certificates or published obituaries, but it can be other things as well. But this can be a really sensitive time in an employee's life. So, as an employer, you may not want to require employees to provide documentation, proving someone died, just to get their 5 days of leave. On the other hand, if you have concerns about the workforce abusing this leave, it might be something to consider. It is an option. We did have a case where the employer doesn't require any sort of proof for bereavement leave, but they do track its usage. And if someone takes a very large amount, that sort of triggers an investigation. And it turns out there was an employee who had been taking bereavement for people who either didn't fit the category of family member as defined as the statute, and in other cases, were not even deceased at all. So, something to consider. And then just make sure whatever option you do choose, it's applied consistently.
So next we have leave following a reproductive loss. And this would be applicable to either any public employee or employees with a private employer who have five or more employees. To be eligible, you must have been employed for at least 30 days. Some important things here to note is they may request leave within 3 months following the reproductive loss event. And while you may initially think of miscarriage, stillbirth, this can also include a failed adoption or a failed surrogacy. And this leave would be up to 5 days of protected unpaid leave, but this also does not need to be taken consecutively. And if an employee has experienced more than one of these type of events within a 12-month period, then they are entitled to another 5 days of leave. There is some overlap with the California's pregnancy laws and CFRA and other state and federal protected leave. So if an employee is choosing to go on one of those leaves first, they may complete their reproductive loss leave within 3 months of the end of that other leave date. So that 3 months calendar period that may be starting to count down is just extended for whenever they return from another protected leave. So employees may choose to use their existing vacation or personal time or available sick leave to compensate themselves what otherwise be unpaid time. So unlike bereavement leave, where employers have the option to request certification, Employers cannot request any sort of documentation for this type of leave. Again, this is a very sensitive time in your employee's life and possibly traumatic. And so the protections for this law is just to not allow employers to request certification. And you cannot have any adverse actions for employees for exercising these rights. And we recommend you look at a CRD fact sheet to make sure your policies are meeting these requirements and make sure you understand how they overlap with other protected leaves. And again, we'll link that in our follow-up email. So that is the end of all of our specific leaves. Thank you for sticking with us. I know it was quite a bit of content. So just to recap, to have a couple of summary pages, these are all the leaves that we talked about in certain categories. So we have paid leave, but you cannot require your employees to exhaust their compensated time options. That is just the voting leave that we talked about. And employers are only required to pay up for it up to 2 hours. The two leaves we talked about that are protected and you can require employees to also apply their accrued PTO, including sick time, would be the school activity leave and leave for organ and bone marrow donations. And then our more common category, as you saw, we were mentioning it as we went along, would be unpaid protective leaves, but employees can voluntarily apply their certain protected or their certain accrued pay time off. This must be the employee's decision to apply their paid time off options. If employers are requiring their employees to apply certain paid time off options where it's not allowed under that statute, under that specific leave, this could be counted as a form of discrimination under these statutes. And so most of these allow all types of compensated leave that an employee may have. As we pointed out, one of the crime victim leaves specifically does not allow a paid sick leave. As Jamie mentioned, the leave for alcohol and drug rehabilitation only allows employees to apply their paid sick time. Otherwise, it's vacation, personal time off, sick time, and other compensated time that that employer may offer. And so when in doubt, you should reference the statute language, look at supporting state agencies, especially the Department of Civil Rights in California, which often has informational handouts and suggested notice language, which we'll be sending a couple of them in our follow-up email. And of course, you can always reach out to outside counsel to make sure your employee handbook is up to date and is specific about these different distinctions, or just to get advice on how to enforce it.
So some key takeaways. First, review employee handbooks, see if they need updating. Consider implementing policies that at a minimum provide the protections we talked about today, or if you want to, be more generous, as long as it provides the protections that we talked about today, that's the minimum. You can always go beyond that. And I think the key thing is to make sure that employees who are administering these leaves of absences are trained. They're aware that these lesser known leaves exist and they either understand how to administer them, and or know when to reach out for guidance. And of course, post the notices. Some of these statutes required notices, and consult model language from the Secretary of State and the CRD. I believe some of which we have included in the chat today. So that is it for our content today. It looks like there's a few minutes for questions if people have any questions. And if not, we can always, if something pops up later in your mind, please feel free to reach out.